Hey, Jim, good morning. Good afternoon. You're on mute. So,
All right. Thank you, Michael, for the kind introduction. Aly and Moish, thank you for joining today in what should be a very interesting panel. So since we have limited time, why don't we just dive right into it first with a little bit of background. So Aly, why don't you kind of tell everyone a little about your background, your kind of experience in the space and how you got into it?
Yeah, sure. My name's Aly Sosa. Sosagi on a lot of social media platforms. That's, I think, what Michael was trying to pronounce. I started off in investment banking, worked at Credit Agricole, Goldman Sachs. From there, I moved into law, worked at a securities boutique firm in New York, went in-house at a couple of fintech firms. Fintech then led me to blockchain, graduated in that space, and crypto blockchain. Then, the NFT movement was happening. Decided to start my own firm since I was getting so many clients. And now I'm principal of Meta Legal and serve as an advisor and counsel to blockchain and NFT creators and platforms.
Great. Awesome. And Moish?
hey, good afternoon. So, Moish Peltz. I started out of law school as an IP attorney at an IP boutique. I had worked in entertainment before that, and starting about 2014, I had a buddy of mine that said, "Hey, I'm working on a blockchain project, doing some crypto mining. Do you want to get involved? I don't want to hire some other attorney. I want you to help me." So I started in 2014 doing that, and all the while kind of working on my day job of IP law. Again, 2017 kind of ramped up a little bit with some crypto work, but again, it was more of like a side project. And then beginning of this year. Here we go, right? Everything that I'm doing in terms of interest in crypto and intellectual property all of a sudden merges, and it was kind of off to the races starting in about March, where I'd say the majority of my practice has been intersection of IP and NFTs, leading to our topic today.
Great. Well, welcome. My background briefly, I'm Jim Gatto, I'm partner at Sheppard Mullin. I've been doing IP work for almost 35 years, a lot of work in interactive entertainment space and digital media. Got into blockchain back in 2012. One of my clients actually became general counsel of the Bitcoin Foundation, and he kind of got me involved and started going to the conferences, meeting the people, and it's been a great ride ever since. And been doing a ton of work in the NFT space, and it's certainly accelerated in the last couple of years. And one of the areas that I focus on, in addition to the IP topic we're going to talk about, is the tech regulatory work around this, which is another topic for another day. So today we're going to focus on IP and NFTs, and maybe I think just to set the level set, I think most people probably understand what NFTs are, but I think that people have different definitions or understandings of them. So maybe Aly, if you kind of take a crack at kind of your view on what NFTs are.
Sure, I'll give you the more technical one. It's basically a non-fungible, meaning it's a unique assignment of numbers, data, that has something linked to it, whether it's artwork, photos, audio, whatever it may be. It's linked to an owner in the blockchain. It's unalterable, unchangeable, and it's stored on the blockchain. For purposes, I think, of this conference, we're going to mostly be speaking of JPEGs or NFT in the art industry as it's being used.
Great. Moish, any comment or anything you want to add to that, or any other aspects of that?
Yeah, I mean, I was listening into the last panel and just thinking about that concept of, right, it's ultimately it's a hash, it's a record on the blockchain that refers to some other item, potentially like IPFS kind of file, right? It could also be on the blockchain itself, right? You can have some of these NFTs are like the entire NFT, right, is stored in that hash itself. So there's all sorts of things that I think we're seeing now in terms of the JPEGs, right, being the basic example of an NFT, but I think the fundamental technology allows for an unlock of all of these combinations of, you take these assets with you and you combine, IP embedded in one NFT and you import that into a video game, for example. And so when you start, using these NFTs in kind of like thinking in the future, like second level type gaming transactions and combining them, it starts getting really complicated and really interesting, I think, from an intellectual property perspective.
Yep, absolutely. Yeah, so I agree with both your kind of definitions. I kind of look at it not maybe from a definitional perspective, but just from a trying to, when I talk to clients, help them understand the issues. There's really kind of two parts, and you guys touched on it. There's, the recordation of ownership, which is recorded on the blockchain associated wallet, and then there's some asset, could be physical or digital, that can reside on or off chain, and you have these two things to deal with and one references the other. And I would use the analogy of like a car and a title certificate for the car. The title represents ownership. It has a VIN number. The VIN number references the VIN number of the car. It gets stored in a database, but the car is out, on the streets, right? So the two are separate but linked, and one is just a representation of ownership. It's kind of a simplification of what's there, but I think it's helpful to look at it that way as we kind of look into the IP issues, because the NFT itself, which is the recordation of ownership, is what it is, but there's still going to be, for purpose of today, a digital asset, and there's going to be ownership or license rights in that, and that's kind of where most of the IP issue arises. You can have IP in tokens, but maybe we can just kind of pause there for a second and focus on the kind of there's various structures out there as we kind of all know with respect to ownership versus licensing of the actual digital asset that's associated with the NFT. I know, Aly, we spoke about this. You have a number of clients that are artists. I know there's many different models that artists use when they're creating an NFT around their media. Maybe you could speak to some of the different models that are being used.
Different models for,
like as far as the rights associated with the digital media that's associated with the token. So anything from, in some cases, straight out ownership, in other cases, licensing of limited rights, and various things in between.
Right. So I think it'd be helpful to explain that with NFTs, right? There's different genres within this space right now. So with digital art, for example, you have collectibles, you have fine art, you have PFP, so on and so forth. So for depending what your client is doing, the type of project will probably require a certain type of terms or licensing agreement. For example, degen projects that are 10,000, for example, degenerative, they are more likely to provide commercial rights, licensing rights, very generous, liberal licensing agreement for their buyers to allow them to be able to do derivatives, to a certain extent, merchandise. If it's fine art, they tend to keep that with photography or audio, or they'll do segments of it. Sometimes it's audio visual, so they might be able to allow a copyright license on one aspect of the NFT, but not the other. So they'll dice it up. But for the most part, you start seeing, like I said, derivative rights, limited commercial rights, and that's pretty much it.
Yeah, and so I think that kind of one of the key things is not really a right or wrong way. I think based on the nature of the assets and the IP owners' objectives, you can license as much or as little as you want, just like when you license other digital media files. We do see a lot of situations where the IP owner will license rights and reserve copyright ownership. So you kind of own the token, but you only get a license to the NFT, but we've seen other scenarios as well. Moish, any thoughts on that, or anything else you want to add on the kind of just the license structure itself, the different types of licenses that you've seen?
Yeah, I mean, I think it's always helpful to think, both in terms of inbound and outbound IP rights of who are the IP owners, what are their interests, and how are they getting, whatever IP that they own into the NFT. So, there's all sorts of, the degen projects, as Aly said, where, a lot of these things are being made up, or you're hiring an artist off Fiverr to develop traits, and then they're being generatively put together, or there's a coder developer type team that is, like an art blocks type thing, right? So there's things that are generated basically for the NFT. And then there's a whole world, and Jim, it sounds like you've been doing a lot of this work, and we all have, right, is there's legacy brands that are figuring out what's the safest way to get my valuable IP from the NBA, from everything else into, an NFT, but also in a way that is going to make the stakeholders of that IP comfortable with licensing that IP into this context, right? Because it still is, even in, kind of, a year here, a year into this, there's still a lot of questions that people are having going forward. So I think, how are we doing it? Are we doing it in a safe way? What's the future ramifications of that, right? There's a lot of people that I think pretty much every major company right now is there's someone inside the organization thinking about, how do we do this? Is NFT something we can do for our business? And then the outbound, right, of, again, the degen projects are often, there's some that are doing, Creative Commons, like just complete releases, all the way to very, very limited rights to just, you can own the NFT and you can display the NFT and you can resell the NFT and that's it. And then we'll get into later, I think, of how that license is presented to the buyer or user or licensee that's going to ultimately own the NFT, I think is a really important issue as well.
Right.
I think it's,
right.
if I'm
Please, Aly, go.
I think it's important to understand that when you're providing a licensing agreement for derivatives, it almost always goes hand in hand with the right of publicity, some commercial rights to a certain extent. Otherwise, the derivative right doesn't, for personal use, it's not compelling to the community, right? And it's symbiotic. It's a symbiotic relationship for both sides, where the degen project gets exposure, people, it engages their buyers, the community that they've built up, into being able to take their own rendition of the original work that they bought and play with it a little, allow further collaboration. So I do want to specify, usually, almost always, when you do that licensing agreement for a derivative, there is that commercial right. And yeah, that's all I wanted to.
Yeah, but there does seem to be a range, right? I think some of the art blocks ones are very popular and commercially successful, and I think a lot of them are subject to a relatively limited license. A lot of the photography ones, I think, are in the same boat.
Right,
so
that's why it's called for degen. You don't really see it for photography or audio.
Yeah, for sure.
Right. So I think that's kind of a great overview there. I think the key takeaway there is there really is no one right licensing model. You can really structure it in almost any way you want, from straight out ownership of the asset associated with the NFT to a permissive or restrictive license, whether it's commercial, non-commercial, or any other conditions you want to apply. So one of the key issues, and Moish, you kind of touched on this, and it's a great segue into the next kind of topic here, is, okay, so you've decided on the license that you want to apply to your NFT. How do you make it enforceable on the initial buyer and subsequent buyers?
So would you like me to start, or Moish?
Sure. Yeah, go ahead, please, Aly.
You have all sorts of issues as far as notice to the buyer. The very nature of the NFT, you're not really able, theoretically, you could incorporate an entire licensing agreement onto the smart contract, but it would run very slowly. The transactional cost would be very high, and the environmental cost as well. So most people either recommend attaching it via IPFS or AWS. There are issues with IPFS and that their code, their metadata being exploited when you have an ongoing drop or collection where the entire collection hasn't been minted yet, that I'll discuss a little bit further, but not to derail. Most of what I'm seeing now, they just do, they include it in their terms of service, or they have a designated website where that license agreement is displayed. It's also shared on their Discord and other mediums that they use it on. That seems to be the best way of doing it. But like I said, you also have the option of including it via IPFS. But and I don't know about Moish, but as far as the contracts I've been drafting, but you obviously include a clause that just by using the NFT, by purchasing it, there's some, you're adhering to these terms and conditions. So there is no requirement of a signature or any checkoff on behalf of the buyer. So.
Yeah, I think that's exactly right. And, it's a question, I think IP attorneys have been kind of grappling this, probably also pulling our hair out for a while in terms of this. You look at the courts trying to decipher, click wrap type, what does that mean? How is it presented to the user or purchaser? And I think, I would have imagined that these things would have been solved 20 years ago, but I think courts can still be confounded, I think, by some of these things. And certainly there's been best practices adopted in that context. And I think, we're seeing kind of emerging best practices adopted in the NFT context in terms of how a license agreement is presented and what that best practice might be and what some of those terms that might be expected from a user might be. But I mean, ultimately, there hasn't been any test in the courts, right? There hasn't been any, real like push back and forth where someone misuses a license and a project is going out to enforce and get them to stop doing that in a court ordering saying, hey, you stop that. And then you even get to, well, if there's just an anonymous, wallet misusing, how are you going to actually shut that down and enforce it? So I think like we're in the creation phase here, and we're trying to figure out, contextually, project by project, what makes the most sense and what's going to, hopefully translate those rights as best we can, and what's going to, I think also just communicate to the community what are the standards that are expected and what is beyond the realm of what is allowed. But then I think there's a whole kind of thinking through the future implications of, what happens when these things go wrong, what happens when there are disputes, what happens when it's owned by, a decentralized organization, who is the entity that's going to be enforcing these rights, how are they going to access the courts? I think there's a lot that just hasn't been really thought through there, which I'm sure between the people on this panel and the people in the audience we're going to be working through in the future.
Yep. So you mentioned, I want to go back to part of what you said there. I think you covered a lot there, and that was great. And Aly as well. I think Aly really captured a lot of kind of what's currently happening. Which you referred to the kind of the click wrap cases. Generally, at least in the U.S., this is still just the basic issue of contract law, right? You typically need to find some way to have valid acceptance of a contract if you want it to be binding. And the cases you referred to, most of the courts, and I agree, they're still grappling with it, and there's some one-off decisions here and there, but many of the courts in the U.S. require some affirmative, notice and affirmative acceptance by the user. Even if it's just clicking a box saying I agree, and you present a link to the terms and juxtaposition of that and all that. And that's kind of the standard with websites in general. And I think if you're buying an NFT in a marketplace, it's not necessarily anything inherently different. There's different ways to get that I agree, license. One of the challenges is that, if you're selling on a marketplace, the marketplace may have a terms of service that users have agreed to use the marketplace, but individual NFT owners may want different license terms to apply to their individual NFTs. And there's some ability to do that. Not all the marketplaces have that flexibility, but one of the analogies I think that is probably the closest model that's been around for a long time that seems to work is open source software, where like if you go to GitHub, they have terms of service for their platform, but each open source component will have license information, which you may have it in a header file, or it may just be notice on the GitHub the Git page for that project. I think what do you guys think about that as far as maybe a part of the solution or direction to ensure that these NFTs have binding licenses from the get-go? Any thoughts on that?
It's difficult, right? As you mentioned, a lot of people are choosing to, not a lot, but there's some projects that are choosing to do it on their website, which I think you could find a work around that, right? Implement you agree before the purchase is completed. But when you're on a platform and the template's already there, and you can't really tailor what terms you want your buyer to agree to, I'm not sure what requirement, because even in the description of the NFT, would that suffice to inform them that there's an agreement, or go here, because there is no acknowledgement on behalf of the buyer to inform you that they indeed read that.
Yeah, that is one of the challenges, is getting the affirmative acceptance, and there are some sites that provide some mechanism, but definitely not across the board. So let's kind of just take this one step further down. So let's assume that you go to a marketplace and you buy an NFT, and let's assume there's some license information displayed, and you affirmatively accept it through whatever mechanism is there, and you own it. Now you want to resell it directly to someone. You don't go through a marketplace, for example, or you go through a different marketplace. How does the second buyer, how does the license get applied to them? How are they aware of the license terms, including particularly if there's any restrictions on no commercial use or any of the other restrictions we talked about under some of the license cases, and how do you make that binding on them?
I don't.
Yeah, go ahead, Aly.
No, go for it.
I think it's that same question, right? I mean, there's certainly ways that you can put the information in all the right spots. It's in the metadata, it's in the description, it's in the contract, it's in everything else. But you know, you're right. It's a contract question. Is there affirmative acceptance? Is that needed or not? Does that matter? I think we'll, you know, from a U.S. perspective, we may end up seeing this issue be litigated, right? And then that's why you're seeing, I think, a lot of big brands are instead of just releasing it through some open platform, are gating their NFTs behind, you know, some other private platform where it's a little bit closed off, and you have to explicitly agree to the terms, right? You have a click wrap agreement where they're expressly agreeing to that license terms as a condition of participating in that NFT marketplace. But you know, I think for a lot of reasons, there's projects that don't feel that's appropriate, or you know, there may be a desire to not have that kind of marketplace. So I think the question is, like, you know, what can, you know, we do as attorneys, and what can these you know, projects do to, I guess, maximize their opportunity for making an agreement that's binding, for you know, and then ultimately going to be enforceable.
Yep.
Just want to add to that. I think, you know, any solutions that I come to mind with, you have to take into consideration the stages of which NFT are in at the moment, and how literate people really are with certain terms, metadata, being able to look at smart contracts and going in there. So one alternative solution is maybe put a hash in the smart contract that leads them and informs them that there's a licensing agreement tied to it, or again, IPFS. But when you have mainstream adoption or onboarding, do you just impose that know-how, or do you just you know, assume that the buyer is going to understand those technicalities? And I think this really brings an issue of either being misled, they don't know, they're not informed with if there's a licensing agreement, and also to a certain extent being misled related to, you know, some people, I mean, not early on, some people felt that when they were buying the NFT, they were buying the intellectual property itself. Mm-hmm. So there were some cases with Dapper Labs, for example, where that was one of the issues that was brought up. So I think all of that needs to be addressed, right, in order to ensure that consumers aren't misled and really have full information of what's tied to the NFT. We haven't found a solution yet.
Yeah, and on those cases, there's, you know, this is not the first time this has come up. But for those you remember, Second Life, they had a number of situations where they had at least a couple of class actions against them, where they were saying you could own virtual land, own, you know, different items, but the terms of service made it clear you're only getting a license to it. And if you know, there were a couple of folks that had their accounts shut down. They said, okay, fine, we did it improper stuff. We shut our account down. We want the value of what our assets were that we paid for, that we owned, that you told us we owned. And you know, Linden Lab, the owner of Second Life, they said no, your license terminates if your account terminates. And so those ended up getting settled. But this issue's come up before, and I think part of it really goes to, you know, as a, you know, marketplace and or IP owner. The more you have an effective acceptance and valid contract, you can license, and you can have licenses be terminated, but you can't just say that's going to happen. People need to know what's going to happen. They need to accept it. And to your point, Aly, which I think is great, is your marketing needs to be consistent with what the legal realities are. And there's definitely a bit of mismatch of that on some of the public marketplaces that say, hey, you can own this, and when it's not in fact the case. Let me get one more topic in real quick, and let's try to be brief on this. I know there's a bunch of questions. So what are some
just one quick point? Sorry to interrupt you, but,
yeah,
but I mean that just really made me think of. I know it was reported that Vitalik Buterin said this week that one of the reasons he developed Ethereum in the first place was because he was playing, I think, World of Warcraft, and they took away all his in-game items, and he was like, well, screw that. So I think we have to recognize also that some of the what's going on here is a desire to like explicitly avoid that and to own assets decentrally and not have the ability for them to be taken away by some centralized organization. I think that's kind of what's going on here as well.
Exactly right. Great point. That's a good kind of macro view of kind of where we are and where we're going with some of this. So the other topic I wanted to cover real quick before we get into some of the questions is just from the enforcement perspective. So let's assume you've licensed, IP as part of a NFT. You've got some valid license out there. I think you touched on this earlier, Moish. I mean, if you have an anonymous wallet, how do you go about enforcing rights if someone has either used your IP without permission or exceeded the scope of a license, for example? Or there's other scenarios for IP infringement, but what are your thoughts on some of the key enforcement issues that people should be aware of?
Yeah,
Aly, if you want to start.
Aly, go ahead.
Sure.
Yeah.
There aren't that many, unfortunately, right? The nature of how the platforms are widespread. There's Anon, so a lot of anonymous wallets and buyers. So you actually don't know who you're dealing with. So if they end up breaching the license or infringing work, how do you come at them when you can't retrieve information of theirs? Most people have resorted to DMCA, Digital Millennium Copyright Act. If you end up finding your work that's infringed on a particular platform or website, they end up finding, just filing that, and that gets pulled out. But unfortunately, I feel like that's also being abused. You're starting to see competition arise, or people that are demanding, certain funds or something. They're just exploiting the artists and filing false DMCA suits just to pull that. But to your point, that's one of them. If you don't know the person's information, unfortunately, there isn't much recourse you could actually have to enforce your license.
Yeah, I mean, I think the other point is just thinking through again from a U.S. perspective. If you're going to initiate a copyright infringement case, you need a copyright registration, and if you're a decentrally owned anonymous organization, like how are you going to get that? If you don't have a work for hire agreement with your artists, how are you going to get that? So thinking through, like, how are we obtaining IP ownership in the first place? Who is owning that? Is it an entity? Is it a DAO? How are we going to access the courts if for some reason we need to in the future, right? So that before you even get to enforcement, it's like we gotta get ownership, because you're not going to be able to enforce unless you can prove your ownership, and that's what the courts are going to make you do.
Right.
And then you're seeing, Aly mentioned, right, the DMCA's work if all the activity is happening in OpenSea, for example, you can DMCA OpenSea or one of the other platforms. But increasingly, I think you're seeing a lot of the activity move away from those platforms, and there's becoming, I think, increasingly, comfort with people trading like outside of that environment. So it's going to make that task more difficult, and I think it kind of leaves the NFT projects or the artists or brands or whoever the IP owners are just kind of like taking the responsibility to do that diligence up front and to figure out, stress tests. If this goes wrong, like how are we going to, what's our recourse? Be thinking that through. So when that thing happens down the road, you're not surprised and kind of left without an ability to do anything.
I just want to say it happens on the opposite side of things as well, right? Consumers can be scammed, and they have been, unfortunately, where somebody will create a project. It might be infringed, or it might just be work that they actually did generate. They put out this roadmap and all these promises of what they're going to follow up with the actual NFT that's bought for the buyers, and they end up scamming them. So, and there's no recourse for them as well, because the wallets and there's no actual person identifiable on the other end.
Yeah, it is a challenging issue, and I think I agree that on the one of the most effective means is a DMCA. If takedown notice if the NFT is still on a marketplace or other platform, and we've had a number of those that are successful. The key, I think, is and again, there's different players in the ecosystem. I represent a lot of brands as well as artists, but the brands in general have IP infringement analysis tools that they use for the web and other things to identify where their IP is being misused. And I think the key is they need to extend that to the marketplaces to catch it early, because if you don't catch it on the marketplace, as both of you well said, that it becomes very difficult once you're chasing an anonymous wallet owner to try to get any, you can file a DOE copyright infringement suit, but over what? What is a court order going to do? If the file is located and you can somehow get it, access to wherever it is, but there's layers of complexity. So I think the short answer is catch it early, do the DMCA on the marketplace. And if not, I think we'll see what evolves as enforcements go forward. And as we know, I mean, the government is using tools that are analytics to identify wallet owners, and I think those will become more prevalent as well. But it just makes it difficult for the average brand owner at this point to do enforcement if it goes past the marketplace. Okay, so we have a question here: if I mint and publish an NFT on OpenSea, can I publish the same NFT on Nifty or vice versa, and/or future platforms? Aly, you're smiling. Why don't you take that one first?
Yeah, I hear this quite often.
Yep.
So it depends, right? Our go-to for attorneys. If you're listing it as a one of one, no. I mean, legally speaking, no. You might have some consumer deceptive practices if you are listing it as a one of one and actually having it in multiple places. You also run into the problem that if it is a one of one, if somebody buys it simultaneously on Nifty and then on OpenSea, then you're liable, right? Because the person buying it was assuming that it was only listed on one particular place. But I think this is less of a legal question and more of a reputational and kind of what's accepted amongst the community. And to my understanding, it's kind of frowned upon if you have it listed on multiple places. So even if you have a 5 of 10 and you list them in different platforms, it's generally frowned upon to be shopping around and bouncing and displaying it on multiple platforms. But legally speaking, no, unless you're misleading your buyer and stating that it's one of one and you're doing multiple of them on different sites.
Yeah. Yeah, great. Yeah, I think there's definitely the business issue there and the reputation issue, and yeah, legally there's no prohibition on it if you own the underlying asset and there's no contractual agreement you've been entered to do otherwise, or any representations you've made to buyers. I mean, I think under those circumstances you can kind of do what you want, but you run the risk of kind of the business issues that Aly mentioned. Okay. Next question here is: do you think they will let their players sell their favorite footballer? Not sure I fully understand that question. I mean, is that? I think maybe let's assume the question is: can you create an NFT based on what one of your favorite footballers, and what rights would you need to be able to do that? Perhaps is embedded in that question.
So this is kind of an issue that you're having just with artists as well, right? They are starting to bleed into NFT space, metaverses, and some of the contracts that they're in might be a 360. It might actually cover and extend to anything that's digital art or this kind of medium, in which they don't have the rights, unfortunately, to use their likeness or their IP associated with their uniform or whatever it is that they're trying to NFT. But say they do have those rights. You kind of see that with the recent case with college athletes, and now them allowing them to use their own IP. I'm advising on a particular company that's doing that. That's gone several athletes, several from the University of Virginia, where they're using their IP and they're doing like their ring, their and their logo and their what. Yes, they're able to do it, but you have to see if they're contractually binded or if there's a conflict of interest elsewhere, and they're able. Sometimes they're able to use their personal likeness, but not use the brand or the name of the institution that they're with.
Yep. Yeah, that's interesting. And I think kind of related to that, and I think you maybe touched on this, Aly, is that there's a whole interesting set of cases out there of photographers who have taken pictures of celebrities, and a number of them have created NFTs based on their pictures. And just from a right of publicity law generally, and it can vary, it's not consistent law throughout the US, but in general, as a photographer, if you rightfully took a picture in the first place, you can sell your picture or license your picture. And even the celebrity can't use it. There's been cases where celebrities have posted pictures of themselves on their social media, and they've gotten sued and they've had to take it down because they didn't have a right to use the copyrighted work that the photographer owned. But one of the interesting corollaries with right of publicity is that, but if however you're using that photo to sell something else, then you typically dabble, you kind of cross the line into right of publicity law, because it implies, at least potentially applies, an endorsement by that celebrity of the something else you're selling. So relating that to NFTs, the question here is, if you have an NFT that represents a photo of a celebrity, let's assume the artist took the picture, had the right to do it out in public and all of that. Are they basically, through the NFT, selling rights to the photo, or are they selling the NFT? Is that a different object that they're selling, that they're using the picture of the celebrity to promote? Any thoughts on that question?
I tend to side with the latter. Usually that they're, at that point, you're making a profit out of it, right? So maybe you have the right to the copyright within that picture and everything that's held, but once you start making NFTs of it and making a profit, I feel like that's no longer protected.
I think I come out on the other side of that, it's probably contextual, right? Again, it's going to depend on how it's marketed, right? If you're saying this is an NFT by, or with some involvement of the person who's depicted, celebrity, then yeah, that's a different situation. But if it's just, here's an art photo and I am the artist and here's my NFT of my artwork, I tend to think, as long as it's done the right way, that would be would typically not be a violation of the public right of publicity. But I don't know. I think, again, this is one of those things that we're going to see how courts ultimately treat these things.
Yeah, I think it is interesting. I think if you again, part of it goes back to one of our initial questions of how you look at the NFT. I mean, if the token is just representing ownership of some asset, right, then arguably you're selling the asset, and under that analysis, I would probably apply with Moish. But if you look at the NFT as something different, and that's what you're buying, and the photo was used to represent it, then maybe Aly's view is there. But I think really the right answer is it depends. Like so many of these things, it depends on the context. It depends on other factors. But I think it is going to be. We've seen a number of situations where this issue has arisen already, and I'm sure there'll be plenty more as time goes on. So I think we are kind of close to wrapping up here. Before we go, let's just do real quick, Aly, any parting thoughts or general words of wisdom to people in the NFT space about IP that we haven't touched on yet today?
Moish and I talked about this a little bit. Work for hire agreements to protect your IP, especially in the NFT space. You have a lot of collaborations going on. Collaborations being done by would be traditionally you'd hire someone for work for hire, but also back end development. Make sure you get those in place. Make sure you have clauses that stipulate that the end product and the copyright all goes back to you, just for added protection. But yeah, be careful with, I think most of the space is concerned with SEC law, which is great because that's my space, but also consumer protection. Just be sure to properly disclose things to your consumers, so you're not being a reputational cause or even an unfair and deceptive practices claim. So that's it.
Great summary. Moish, anything else?
Yeah, that about sums it up. I mean, I would just say, if you can, work with an attorney to kind of identify these issues and figure out what you don't know. And it's a really fun and interesting space, and I'm really loving it. If anyone wants to connect, I'm on LinkedIn or Twitter, Peltz. It'd be great to connect with people and learn more about where IP goes in this space.
Great. Well, I'm sure people will reach out. And Aly, I think you mentioned earlier, but I want to give a shout out to your social media handle.
Oh, sure. Thank you. It's Aly Sosa, Twitter, which is the one I'm on Clubhouse. I'm on all the mediums, but I tend to check Aly Sosa more. It's ASOSAGUI.
Great. And people can reach me at James Gatto on LinkedIn. I'm with the law firm of Sheppard Mullin. Well, this has been a great panel. I hope we get a chance to do this again, maybe in a year, and hopefully there's some further clarity that we can add to some of these really interesting issues we touched on today, where there's not merely a clear answer, but here's some best practices. So hopefully everyone enjoyed this and got something out of it. And hopefully we'll get a chance to do some updates as time goes on and things develop. Thank you all very much. And thanks to NFTCON, and we're glad to have the opportunity to do this.
Thank you.
Thank you.